Yes, sir.
Your Lordship wanted me to assist Your Lordship. If I can give some input on the question, Your Lordship asked me that last occasion. If Your Lordship looks at the last order,
Give me the file. Date.
so 31st October 2025.
31st.
October.
Yes. Yes.
Well, that is the reason why I am here first.
Yes, yes.
If Your Lordship looks at the reference order, 2910,
Yes.
because I'll speak only on the legal aspect of it.
Yes.
It's in interpreting the provision of Rule 824, 835, and 837 of the Police Manual. The full bench of the Odisha Administrative Tribunal had laid down its judgment dated 18/5/2021 in OA 2723 of 2008, which reads, thus we answer that the black mark value contained in Rule 835(1) does not have effect expiry of period for which the reduction, forfeiture, or withholding has been imposed. In such cases, the black mark shall not remain permanently under Rule 837(1). Further, the black mark shall remain permanently under Rule 837 if it is awarded separately as a punishment prescribed in Clause F of Rule 824. But this decision of the tribunal was put to challenge for this Honorable High Court, where the writ application has been dismissed. In fact, in that judgment, as I find, no detailed analysis has been made. But subsequently, in another matter, the matter was placed for the Honorable Court, and their lordship, I think,
It was on a delay ground. It has gone, keeping the point open.
correct.
So it was not decided as such.
And that is the reason why actually the reference has been made. If you lordship looks at paragraph 7, whether the opinion recorded by the tribunal in its judgment dated 18/5/2012 in OA 2723 of 2008 to the effect that the value contained in Rule 835 doesn't have effect upon expiry of period for which the reduction, forfeiture, or withholding of is imposed, and in such cases the black mark shall not remain permanently under Rule 837(1). In view of the clear stipulation in Rule 837(1) that the black marks shall remain permanently on record and be taken into consideration in deciding the nature and extent of subsequent punishment. 2, with a view taken by the division bench. Actually, no view has been taken as such. So, number 1 is the main reference clause.
The only thing is that the black mark will remain permanently,
or it will extinguish.
attributable to the conduct of the delinquent.
Correct.
For the purpose of ascertaining the quantum of the punishment or something is to be
Correct.
given.
That's the
So
only
all
point.
these things are there.
But the question here is, Lordship also knows that court cannot add or subtract anything to the statute.
Exceptions is also there.
Right. So therefore, once a statute particularly says something which has to be either interpreted in favor or against, that's a different matter. But it has to be read, if it is in clear terms, mention something which is not ambiguous. If it is ambiguous, matter is different. Interpretation is required. If it is not ambiguous, it has to be accepted as it is.
Plain and simple meaning.
Plain and
there
simple.
is no ambiguity in it.
No ambiguity. So that is the reason why I would like to say that I feel after reading all those provisions, because I have gone through the entire statute and all that. Statute in the sense the rule that is framed. It says that it doesn't have any effect so far as the reduction of rank or reduction of promotion rank or anything. That doesn't have any effect on it. If that goes, that is for a particular period. So that period extinguishes, the black mark as such cannot go, because if your lordship looks at provision, it itself clarifies. I'll show your lordship one thing. I'll take your lordship to the particular rule. The rules relating to black mark.
So the real allied question is whether it has a statutory effect. Why should the court will interpret if it is not a statute?
So it cannot be said to be a statute unless it has got the sanctity of law, as provided that it has to be placed before the legislative
It
authority.
relied upon a Supreme Court judgment where it says that it doesn't have the statutory
Sir, I have gone through that judgment. I'm going with my friend that he provided me that judgment. Paragraph 14 of the judgment clarifies that position. But that is actually, I still feel that is some haziness or nebulous approach. The reason being, this rule has been framed as it appears in 1937. 1936, Orissa became the province. So 1st April 1936. And thereafter, Orissa Police Act also came into force. That is a state act. But at that time, whether it was placed before the state authorities for approval, that no record is available. That is exactly I wanted to verify from the Government Council. He says no record is available in the record room or in the law department. So that I feel that must have been approved. What I feel, otherwise it could not have been followed for years together.
That is on a principle that the presumption of the legality or
Yes,
or its effectiveness is presumed unless
contrary
it is proved otherwise.
Right. Unless proved otherwise. And your lordship knows the Constitution provides a law which is being followed has to be approved, unless something different or repugnant or inconsistent with the
constitutional
provision. So here I don't think there is any inconsistency so far as that part is concerned.
Now that maybe if you feel that it must have been approved because of that asterisk in their compendium.
Yes.
I may say that compendium.
Yes.
Published under the authority of
Section
it is
7.
government press publication,
yes.
no?
Yes,
which you have supplied one copy, which departmentally they use it. Every department they have their own compilation. So that compilation itself shows asterisk marks are the executive instructions and formulated under Police Act
1861.
1861.
So that has got sanction under section 12 or
7.
7.
12 7.
But those rule mark, which is not asterisk mark, what would be its impact?
So if it has not been assented by the legislative authorities, it cannot have a statutory force.
The second aspect is, if in a legislation or in a let us see the document,
right,
which is not a statutory document but an executive instructions, whether by virtue of a legislative pass you can amend.
But I think it's not permissible under law to amend it.
How?
The reason
because the genesis of the foundation does not appear to be a statutory in nature. How can, by virtue of some statutory powers, you can bring something into it?
So I don't want to say that word. I don't mean that. What I meant beg to submit, my lord, we cannot. We mean the judiciary, right? The court cannot create a law.
True.
It cannot be created by interpretation.
Just decis. That's the principles.
Therefore, what is there in law, but if we don't go to that aspect, statutory part of it, the procedure that has been followed for years together, what I beg to submit for lordship is, if we follow it, then the question that is in reference that is there, that can be answered. if we don't disown that and the rule is not valid and rule, but that way actually it will have a tremendous impact so far as the police department is concerned.
True. It's a larger ramification.
A larger ramification will be there.
From 1940, that is being
That will
Oh,
remain
yeah,
as a
just
guideline only.
sir,
It
that
will
is what
internal guideline only.
we are also keeping that in mind.
my lord, after much ponderance, my lord, yesterday I could able to find out a gazette notification, Odisha gazette notification. If your lordship may kindly see, given 3 copies of 1936, where my lord they adopted Bihar and Odisha Police Manual 1931. Your lordship may kindly see. So every time I go for a search, I come little bit closer, but I've tried to find out this is of 1936 and 1940. One that is my lord, a police order.
That was in relation to only 2 districts, Ganjam and Koraput.
No, my lord, except those 2 districts. That is what it says.
A sub,
Except
except.
Except
the-
Ganjam.
those 2
So
districts.
at that time, entire Odisha as we see today
Yes,
was not included in Odisha police.
No.
because like a
Odisha
province.
Subsequently, like Garjat and
Represents.
Ganjam and Koraput.
Garjats never came. Princely states.
So
they
that
came
you
later.
that you'll also will get from this document, Bharat. I have collected it from the internet. How Odisha actually was formed, and at different times the different districts were formed.
Mr. Das can get some information from Odisha Gazette. Odisha Gazette.
Yes,
Right.
Odisha Gazette is
Odisha Gazette.
So that is only available either in Judges Library or government press.
My lord, from government
can
press,
No,
last
actually-
occasion I produced that instruction, government press, it is not available. That director of prints has given it up.
Assembly Library must be there,
Only
or
one
Judges
place
Library.
where I have not searched out, that is my lord's library, so that I can, if
No.
my
in the state archive must be there, Bharat.
state
In
archive,
state
so
museum archive, old documents are there available. Provided you go for it and search a particular document. Now they have
and
digitalized.
this particular document of 1936, this also throws some light. If it is there, then subsequently 1940, there must be something which has, and this. So, Lord,
So, Lordship, kindly have a look at this Odisha police. But from 1st April 1936, when the Odisha province was there, that the district, how it was formed, how the applicability of the rules and the act was made applicable in different times. He has given a detailed chronological event in different years and month and date also.
and state of Bihar, Jharkhand, Madhya Pradesh, they also have those police manuals. Lord,
So they have traced the history that from the medieval time, even before that, there
Yes.
was always a concept. Even in a princely states,
yes,
they had their own system of
Yes.
administrations, and they have those police concept.
yes,
That is the very is a very commonly known that in order to run the administration, you should have. But the question is that once you have, that's the another something is in place. Now, question is that whether they are guided by certain rules.
yes. And
In a princely, it is only the king's,
once,
the sermons which was final.
Right.
But subsequently now, a robust system has been introduced to regulate their functioning, they regulate their system.
The Odisha Police Reservation Act, different acts have come in the meantime.
Absolutely, that is what is
And
required.
rules have also been framed.
and once we
Uniformity
take,
and the certainty is the hallmark of the
Yes.
proper, I would say, the healthy administration.
And once we take penal actions, it has to have some statutory backing, otherwise
Definitely, sir. Otherwise, it will, may I say, it will really create an anarchy.
now number of multiple proceedings are pending, my lord.
Whatever is there,
Why?
you have to regularize only by adopting some method.
True, no doubt about it.
So since that Ajay Mia case, Ajay Kumar case, since then you have, I think you have missed to notice the
In fact,
observations
after your lordship asked me
and
to
carry
look
out
into the matter, I talked to the chairman, law commission, because incidentally I'm also a member of the law commission now. So I discussed with him. He said, yes, we have to give a thought over it. So we can also recommend the state government to make a rule, specific rule, independent years of this, so that the cases pending also can be made applicable and can be applied.
From a retrospective effect.
Retrospective.
Are you somehow suggesting that we should defer till you?
Sir, I don't want to say that. But I have already discussed with him. And today we have the meeting at 4 o'clock. We are actually discussing which law requires to be amended, which are to be repealed, and which are to be
That is
done.
what the law commission's
Right.
main purpose is.
Right.
Just to recommend any amendments,
Right.
just to recommend any promulgation of the law, considering all this present scenario and the
Correct.
difficulties.
The other day, Your Lordship, you should notice in that Jagannath temple matter, I was incidental there in the court. So we have already suggested
It's fine
amendment
that
of
there
the.
has been an overlapping. That is
Yes.
what is the most difficult thing.
The powers under minor mineral rules
That
and
true overlapping.
Yes,
Because
yes.
both the
Lot of provisions are there.
this is one thing that both the acts are complementing each other or
Right.
complementary to each other. And if we find that both are
Overlapping.
overlapping, that's a whole problem. There cannot be two systems which
Correct.
should run parallelly.
here also you have found certain asterisks,
yes,
Madras police orders.
yes. Every time I
So I
go for
think
a search,
from
where
there
I'm
we
trying to
have
find out.
incorporated certain rules into the police manual for smooth administration.
Yes, yes.
And at that time, perhaps DG was empowered to issue.
Inspector General.
Yes, yes.
Inspector
Inspector
General.
General.
Not that.
So here it is mentioned who became the first
Inspector
inspector.
General.
Under
That
the
was
1861 Act also it is Inspector General.
Inspector General. That was the post, the
Yes.
highest post.
Here also it says that the Orissa Police Manual is compiled in 1940. It is a compilation.
Compiled.
Maybe
So
guideline,
like
maybe
mutation manual, Your Lordship
everything is
knows,
compiled.
but there is a mutation manual which is regulates the mutation cases. It's a compilation of different notification circulars.
True, that is what is there. We in other state there is called a land manual also.
Right.
So which contains exhaustive mechanisms. That's when any mutation, when any
It is not
recording
a statute itself.
of the entries are to be altered or whatever under the law. That these are the procedures one should follow.
We follow.
And it has been held that it is merely an executive instruction, and it has got no legal backing.
Right.
The problem is that anything which you want to put in place, one thing is whether it is a legally enforceable right, because anybody, if he comes and says that under this provision is entitled to this protection, whether the compilation as a legally enforceable. If it is not, then definitely one cannot claim any special right or protections there.
So it must be derived from some statute.
Absolutely.
Otherwise,
The
it cannot be legally
the power to make it. So make it by regulations, make it by rules, or you can also make it if there is a power to issue circulars, to issue notifications. If that is also permissible under the Act, there is no difficulty. But the difficulty is
So Odisha is the only province where the prime ministers were appointed in. 3 prime ministers. The king of Parlakhimundi was the first prime minister. Then Dr. Hare Krishna Mahata became the second prime minister. Then the Barampur, I think, just Mr. Das, he became the third Prime Minister.
Vichitranand.
Vishwanath.
Yeah?
Vishwanath Das.
Vishwanath Das.
Vichitranand.
And after independence, he became the Chief Minister.
Premier
Demotion. Demotion.
I think
Provincial Prime Minister.
Demotion.
No, that's after the constitution. Those can no. If I correctly remember, when the Calcutta court building that came, initially it was a Supreme Court of the Judicature of Fort William. Later on, it has now been designated as the High Court. Probably, if I'm not wrong, when you find in annotated book of the Codice Impositors, in the commentaries you will find there is a reference of RSA beneath any of the rules of the province.
Right.
RSA is a rule of the Supreme.
Rule of the Supreme. But it was previously directly controlled from London itself. The Queen was
that was it.
Regulating everything.
So it was during the British colony. It was under the British colony that was by virtue of a latest patent. But anyhow, it has been now High Court. And Justice Imbue was the first Chief Justice, which includes this province, the Orissa province also within that initiative.
Right.
Anyhow,
but if your Lordship looks at the rule as it stands, if the rule, sorry, Your Lordship.
yes.
But if the rule as it stands, if your Lordship looks, this reference can be answered.
That's true. There is no doubt about it. Yeah, actually, the question, the point of reference which has been framed,
correct,
relates to that. That what would happen to these black marks?
Right.
Will it remain permanently, or
so the language itself
will
there,
it
right? If
expire
you
by flux of time?
I can place it and show that how it will stand there.
You considering law commission will sort out this issue, if at all.
So I can find out, but if your supports, but it can be.
Because you are a member, therefore we are.
That will be placing it today. Actually, I'll place it before the board because they have all members should be apprised of it. Then we can fix a date for deliberation. In fact, because there are over 7 members. We actually sit every week or 2 weeks after So if your lordship put it after a month, then I can apprise your lordship about
May
the
go up to February, I think. I feel it may go up to February.
Last week of January.
January.
31st. Yes. The rules that- This is rules of the Colonial Bathroom that will- that will be changed. Because I just feel that things are changing. Illnesses will die. No, this is the-
Okay. Set aside the letter cancelling the non-fiction certificate issued earlier. Yes.
I mean, the pardon, this trying to make a mention that in spite of several memo pension matter. And this is what
Whatever
is
you just.
pension and another is recruitment matter.
Yes.
Item number 2.
Here, my lord, the petitioner is a villager of Maidarpur and also a public spirited person has filed this present public interest litigation for construction of a palo rasta, that is temporary road, my lord. Only 100-meter required so that they can adjust it out of 8 kilometer to 3 kilometer, my lord.
Yes, what you say?
My lord, I have obtained instruction in this matter, my lord, that the decision has been already taken, my lord, for construction of the road. 1 kilometer road is already constructed and remaining 3 kilometers are yet to be constructed, my lord.
So,
My lord, here, my lord.
So the problem is sorted out. They have taken up a decision. 1
My lord.
kilometer, the rest will be done immediately.
Oblige,
One
my
more.
lord.
The instant writ petition is taken up in the
My lord, in this case, the petitioner or the villagers file this public interest litigation, my lord, for direction to the Tahsildar opposite part number 4 to remove the encroacher from the public road, my lord.
So we have already delivered one judgment, I believe.
Milord, I was
We have
just,
said that now you have also said that no tolerance policy.
yes. Milord, here the case is different.
Oh.
Let's kindly see paragraph 6 of the writ petition. Here, Milord, probably the intention is the one development project should not be carried out.
By your effort.
Yes.
After perusal of the amendments made in the instant writ petition.
This application is in the form of
It goes without saying that the maintainability of the instant interest litigation is kept open.
this application is in the form of an APIR. Sarpanch, the Samiti member, Panchayat Samiti member, and other villagers are petitioner. It relates to name of a railway station. Railway track is existing since 1943. Afterwards, for goods, and it was a narrow gauge track. Then it was for passengers of local.
You wanted that it should make a halt at a particular place.
No, halt. The halt is there. The name was Chhaga railway station. Now they have converted it.
No, it was. You want a Chhagaon instead of
Gurudi Jhatia.
Gurudi.
The old name is Chhaga. That the new name has now been.
What is
The Union of India has to answer.
notice 3 weeks? Next.
Item number 5.
May I please, my lord? My lord, here the petitioners belong to scheduled caste community, my lord. Public amenity like a road is neglected in their village. My lord,
What's your this is your duty that you should provide an access.
what is my humble submission, my lord?
File affidavit
Pardon.
2 weeks.
Item number 6.
After 3 weeks.
May I please, my lord? Here the petitioner is a social worker. She approached before this honorable court in a public interest. Where is, my lord, the notification regarding construction of sub-center PSC by irregularity and committing the illegality and allotted the land as stipulated in the guideline without considering the notification. Kindly see the annexure. One is the notification, and according to this notification, annexure 2 is issued by the collector Ganjam as page 24, annexure 2, to all the addressing to all the sub collector and all tahsildars. With due permission, I will go to the. With reference to the subject cited above, it is to inform you that the government has sanctioned number of posts of new sub-center in the state budget of financial year 2023, for which sites are to be identified in the concerned GP headquarters or in a village of the same GP where there is paucity of land in headquarters. It's a direction as the headquarters of the GP.
Sir, both. Either in the GP headquarters or in the village.
Yes, if not.
Provided there is a paucity of land in the headquarters.
Exactly, minor.
So
the next page 25 is the serial number 33. The sub-center is allotted, and according to the issuance of notice, the Tahsildar has issued the.
Concerned with what?
We are concerned with the Dhobadi Mauja, which is the GP has headquarters existing. But as for the RI inquiry, RI has submitted his report
that the pursuit of land is there and the land is suitable land is allotted to D Patapur village. But ignoring that, can you see he has submitted the report
Final
and
response. 2 week.
I is there, my I is there.
IA in a public interest litigation.
But because of they will construct start, they will start.
Let them. Yes.
Item 4, my lord, have issued notice. We are for the 1, 2, 3.
Railway. Railway.
Yes.
Change
Sorry, my lord.
of name, sir. They wanted that the passenger hall, that name should be changed from something to a new one.
They are saying that railway didn't have a power, home department.
Instead of Gurudi Jhatia, you have to put it as Chhagaon.
Chhagaon.
That's all.
Yes. Absolutely.
They
Yes.
want-
Passenger hall.
Yes. Public.
Yes.